So good morning, everyone. Welcome today on this webinar about the International Court of Justice advisory opinion on climate change and the strategic implications for boards. Thank you for being here. It's a very particular webinar because it is organized in a cooperation with different chapters, European chapters, in cooperation with Chapter 0 Netherlands, Boards Impact Forum, who is hosting this webinar, the Climate Governance Initiative Greece, and the Chapter 0 Brussels, and also Chapter 0 France. In terms of the agenda, we will start with the presentation by Frank Kroes from McKenzie. Then we will go to the panel with our panelists who are Anna Barreira, Caroline Ruellan, Statis Potiamitis, and Frank Kroes. Then we will go to the panel when we will ask you questions and we will comment on these questions. And then we will have the opportunity to answer your questions from the chat and then get to the conclusions. In terms of etiquette, the audience is muted and we switch off all the recorders, AI recorders. Then you will have the chat box. Then we would like you to use for communication and comments. And please keep it short and state your name when you are writing on the chat, and also please change your name on the screen so we know with whom we are talking, who is participating in the call. This webinar is being recorded because we are going to make a kind of summary after it. If you have any technical issues, please email to boardsimpactforum.com. So I would like to talk about our network, a few words. So myself, I'm from Chapter 0 France. I'm the board member and the STIRCO member from Chapter 0 France. And we have other chapters participating from the European network. Our network is composed of 34 chapters in 73 countries with more than 100,000 members. Who address climate change in their businesses in collaboration with World Economic Forum. We base our action and our mission on the principles for effective climate governance, which most of you know certainly because you are really very present on our webinars in our network. But among the 8 principles that are structured in different subject matters, the subject we talk today about is relevant to the first group of principles concerning the board's role, which is the accountability, the subject command, and the board structure. Meaning that the board is accountable for the long-term survival of the company, and the board directors have to have the command of the subject and the knowledge and the skills required to lead this mission, and the structure has to be fit enough to be able to address the topic in the right place and in the right way. Yes.
I think you can continue.
Yeah. So in terms of the network, before moving to our first presenter, I would like to tell you that our network of chapters, of European chapters, is the kind of initiative that we have built because we think there are special challenges for us in Europe in terms of sustainability and competitiveness, and it is worth to be together and to support ourselves and to address this topic collectively. Our first presenter is Frank Kroes from McKenzie, Amsterdam, a very known commercial litigation lawyer and arbitrator with the practice in corporate liability domain, competition litigation, class actions, and ESG-related disputes, and also securities litigation. Please, Frank, could you please present to us the first topic, which is the presentation of the case and the advisory opinion, which reinforces the 1.5 goal of Paris Agreement.
Yeah, thank you, Anna, also for your kind introduction. The ICJ issued its advisory opinion in the summer of last year, on the 23rd of July 2025, to be precise. The opinion is 133 pages long, and there are also 12 additional separate opinions and declarations of individual judges. So it's a long read, and I'll try to summarize the case for you, just to set up the scene for our discussion. The case was brought by Vanuatu, which is an island in the South Pacific, I think, that is under threat of climate change. The advisory opinion is not a binding court decision, but it is influential in that it sets the state international law with respect to climate change. And the conclusion of the ICJ is that states have an obligation to prevent and mitigate climate change. The court bases that on a number of international law instruments, the United States Charter to begin with, which requires states to act in accordance with a number of principles of international law. Then the court looked at, obviously, climate change treaties, such as the UN Framework Convention on Climate Change of 1994, the Kyoto Protocol, and the Paris Agreement, in which states have agreed that climate change should be limited to an average temperature increase on the Earth of 1.5 degrees, but also a number of other international treaties and customary international law, including duties for states to prevent significant harm to the environment, and duty to cooperate with respect to climate change. The court also recognized that international human rights law obligates states to prevent climate change so as to ensure the protection of family life and the right to life. And then bases its decision on a number of principles, such as the principle of sustainable development, the principle that states have with respect to climate change common but differentiated responsibilities and capabilities, equity, both between nations but also between generations, and the principle that states should do what they can to prevent serious or irreversible harm. And that leads the court to conclude that states have essentially two obligations. One is a mitigation obligation with respect to climate change, meaning that they should do what they can to limit climate change, with the recognition that not all states have the same obligation with respect to their contributions. Contributions can differ based on the historical contribution to greenhouse gas emissions, the level of development and national circumstances, and that is where the national contributions must be based on. And the second category of obligations is adaptation obligations. So where climate change occurs, states need to take measures to adapt to that climate change. The significance of the judgment is that, I mean, there have been other judgments, obviously, where, for instance, courts have recognized that on the basis of human rights law, states need to prevent climate change. The Dutch agenda case, for instance, but also the judgment of the European Court of Human Rights in the Klima Senioren case. But that was under Dutch law, respectively under European law. And the significance of this judgment is that the ICJ has now recognized that as a matter of international law, these obligations also exist. You may wonder, of course, why this is relevant to boards of large corporates. I think it's relevant along two lines. One is that although the geopolitical situation perhaps today does not make this the most pressing issue for states over time, I think it's going to put pressure on states to level up with respect to the measures that they take to prevent greenhouse gas emissions. And that will obviously have an effect on corporates in terms of new regulation or more stringent regulation. The other one is that because of the principles that the ICJ sets out, courts may find, as for instance, the Dutch court did in the Shell Milieudefensie case, that these principles also apply vicariously to corporations, because they also are under an obligation, generally speaking, to observe human rights law as an indirect horizontal obligation, and that is something that NGOs may use to base litigation on or to put pressure on large corporations. So with that, I think, Anna, I hand back over to you for the discussion.
Thank you very much, Frank. Thank you very much for this introduction of the case. So we have several topics that were raised by this in this opinion, and we are going to discuss them within the panel. The other members of our panel are Anna Barreira, who is the lawyer and founding director of International Institute for Law and Environment, based in Madrid. And she was also legal advisor to the Spanish presidency of the European Union in the run-up of the World Summit on Sustainable Development in Rio +10. Then she was a consultant for the World Bank and European Commission and European Investment Bank on environmental lawmaking and enforcement across countries. And she currently leads several work streams and works on climate change, energy transition, and environmental democracy. Then we have Caroline Ruellan, who is independent director and the board member of several organizations and companies in France, mainly KIKO International, Ardian, which is investment fund, president of SONJ Conseil, and the Cercle des Administrateurs. And she's also a member and renewed member of French Financial Market Authority. Retail Investors Consultative Commission. And Caroline has a very long experience on the advising of boards, executives, and shareholders on governance, board effectiveness, crisis situations, and activism response. And we have also Statis Potamitis, who is also a lawyer, but who is independent director of a company based in Cyprus, but listed on Amsterdam Stock Exchange. And Statis has a long experience advising on insolvency law to different, of course, to its clients, but also to the institutions like the European Commission. And he served as a member of the Hellenic Corporate Governance Council, which drafted the first Greek corporate governance code. And he produced also the rules and compilation of corporate governance rules and practices for unlisted and family-owned enterprises. The first topic that we are going to discuss is the national commitments and legal interpretation of NDCs. We saw that the recent round of NDCs that was produced before COP30 in Belém revealed how states interpret the new obligations. The ambition set the tone for corporate regulatory exposure, and businesses should therefore anticipate more stringent national and international expectations arising from these NDCs. This may give rise to increased climate litigation against private companies. I turn now to Anna. Please, could you tell us, in light of the newly submitted NDCs, how are states interpreting their obligations under the advisory opinion, especially regarding the precautionary principle and due diligence?
Hello all, and thank you very much for this kind invitation to participate today in this interesting webinar. Okay, first of all, to answer your question, I think it is very important to recall what the ICJ has said in its advisory opinion regarding NDCs. I mean, it's a long decision, as it has been said, and regarding NDCs has established different and concrete obligations, but I'm just going to recall the ones that are very important for answering your question. So, excuse me, there is someone talking now from the audience. Anyway, so it says that the court said that an NDC must reflect the highest possible ambition, and the content of a party NDC must, in fulfillment of its obligations under the Paris Agreement, be capable of making an adequate contribution to the achievement of the global temperature goal. And I recall that the court has mentioned that the goal is the 1.5. I mean, the obligation for states is first the 1.5, given the risks under the 2 degrees, though Article 2A of the Paris Agreement mentioned first the 2 degrees Celsius, okay? And it also says that the exercise of the discretions of the parties, it has to be based on due diligence, okay, as you have mentioned. And it also emphasized that when taken together, NDCs have to be capable of achieving the temperature goal of limiting global warming to 1.5. Okay, so it's when taken together. So having said this, it is important to look at all NDCs together. And until now, 128 countries have submitted its NDCs, because as you mentioned before, I mean, the obligation was before September this last year, but still there are many countries that are submitting even after COP30, but still not all countries have submitted their NDCs, their review NDCs, because NDCs have to be reviewed every 5 years, according to the Paris Agreement and also to the decisions of COPs. And there are 128 countries that cover 78% of all total emissions in the world, and 69 countries have still not submitted their review NDCs or the new NDCs for the period. It depends because there are different time frames. I won't enter in that because it was very controversial even in the Glasgow COP. But these 69 NDCs cover 22% of the emissions. So still there is not 22% of global emissions covered by the new NDCs.
Yes.
So there is, there is, for me, to answer your question, I would say that given when all the NDCs have been reviewed, all these NDCs does not help to achieve the 1.5 degrees Celsius. So collectively, I would say that it's not in line with the obligations that have been addressed and established by this advisory opinion. But then we also have to look at the NDCs per country. And of course, I cannot go to all NDCs. So I'm just going to mention and quickly the examples of the EU and the example of China. For example, the EU, I consider that it's making all its effort, and the new NDC that was announced before COP30, the aim of the European Union is to reduce emissions, to mitigate emissions at least 90% by 2040. And from this 90%, 5% will be done through the carbon market mechanisms, okay, voluntary market, which is established in Article 6 of the Paris Agreement. And we have the case of China. China have submitted a more ambitious and progressive NDC, and its commitment is that by 2030, China net greenhouse gas emissions across the entire economy will decrease around 7 to 10% from peak levels. Peak levels have been achieved in China last year already. And also they commit that even they are going to try the better efforts to increase these emissions reductions beyond 10%. And also it's aimed for over 30% of non-fossil fuel energy by 2035 and increase wind and solar capacity to 3,600 gigawatts. So I can say it here in the case of China that it's progressive, that they are making efforts, and we will see if it's their best of efforts. So in general, I would say, to answer your question, collectively, if we look all the indices collectively, I don't think that all are in line with the decision of the ICJ. Okay, yes. Thank you very much. I'm sorry that I took much time. Sorry, Anna.
Thank you. It was very clear. So in light of these diverse situations between countries, are there any risks of exposure for the companies regarding different interpretations of NDCs or lack of NDCs in different countries?
Okay, it will depend. It will depend. It will depend the country. Yes, it will depend on the country. I would say it, and I mean, because NDCs are very long documents as well. So companies will have to look at NDCs where they operate, and to have a clear answer. So and the court already mentioned that everything is in concreto. There are obligations in concreto. So you have to look case by case, case by case basis. Yeah.
In terms of litigation, the question, very short question to Frank, is it any disadvantage, is it any particular risk which is stringent due to the fact that the NDCs are not communicated, or the coverage is so poor, I would say, or there are differences in the interpretation?
Well, I think it might almost be an invitation to NGOs, or at least an inspiration or a motivation for NGOs like Friends of the Earth, Milieudefensie, and the likes, to start litigation to compel companies to introduce reduction paths for their own greenhouse gas emissions to arrive at 1.5%. Although I must say that the Court of Appeal in The Hague has said in the Shell case that there's no legal basis for setting objectives for individual companies when it comes to reduction of CO2 emissions. But I think it's I'm not sure that it increases the litigation risk that already exists, in my view, but it certainly is not going to help if states leave a vacuum, as it were.
Yes, thank you. So we turn to Caroline Statis. In terms of the regulatory risks that are arising around this new constraints about the carbon emissions that are also covered by the Court of Justice advisory opinion. How you think that the board should anticipate and monitor these national and international regulatory shifts in their strategies?
Can you hear me well, Anna?
Yes, thank you.
Yes, okay. Thank you so much for your very kind introduction, and I'm very happy and honored, I would say, to be on this panel this morning alongside such a distinguished panelist. In order to answer your question, and if you may, I would like to just remind us the big picture, the context, because I think we are basically new companies are facing, companies listed and unlisted companies, but mostly listed companies have entered into a new environment and with a deep change in paradigm. I can see three main trends. On the one hand, which is a very important one, companies are now been for long, they were acting out of the city, and now they are at the heart of the city. So now most of them are shareholders. After being shareholder-centric, they are mostly stakeholder-centric. And as a matter of fact, companies are expected to meet new expectations, I would say new demands. In France, it is the Pact law that structured this new environment. Second new trend, we can observe a rise of hyper-transparent, which means that shareholders, stakeholders are expecting companies, executive, non-executive, to be transparent and to provide them with comprehensive information about the strategy and mostly the environmental strategy, but not only. Third trend, it's a rise of accountability. Executives and non-executive are more accountable, and shareholders, stakeholders are now very much eager to trigger their responsibility when they consider that they are not provided with the right information. So we really need to have this new paradigm on mind in order to understand those new demands and those new trends, among them the activist rise. And as a matter of fact, the pressure is emerging in that field mostly from activists, ONG, but not only. So from the board perspective, it means that first, boards have shifted from shadow to light. And second, they are expected to be more transparent and to provide companies, shareholders, stakeholders with much more information, among which the environmental information. Second point I would like to mention, I think we have a chance to get back on this point later on, is board's agenda are now overloaded with numerous topics, new challenges. Among them, of course, the ESG question that has been for long on the top of the agenda of companies in Europe, and with an increased binding regulation. But it's not only this question, and boards have now expected to cope with numerous constraints, risk converging on the board risk. Let's just give you a list: environmental risk, cyber risk, the energy risk, the geopolitical challenge as well, the supply chain, the lawfare, mostly the extraterritoriality question, foreign ingerences, and so on. So to answer the question, the first thing the board is expected is to anticipate. A good board is a board that is able to anticipate. And I think now the challenge for boards is how boards are going to be able to articulate these different risks and expectations and challenges. Thank you, Anna.
Thank you, Statis.
Yes, thank you. And thanks everyone and greetings. I'm very happy to be on this panel and thanks for the invitation. I'd like to sort of go back to some of the excellent points made by Frank and Anna and Caroline, of course. What the ICJ says at bottom is that climate change is an existential challenge for humanity. So it's a big thing. And that seems to be the consensus of many other people. The World Economic Forum just published a poll that shows that extreme climate events are likely to be the biggest challenge in 10 years. So this is not going to go away, notwithstanding differences in political opinions in some of the countries in the world. It's clear also in the ICJ that private actors create liability for states. So states are going to be pushed sooner or later to take additional measures to the ones already in place. I think boards have tools. The first one is the double materiality approach. Climate impact is an externality to corporate activities, to business activities. And that assessment of that externality is part of the double materiality approach. So boards must be a lot more focused on assessing the climate impact of the corporate activities. So that's the first one. Just emphasize that. That's an existing approach. The second one is establish soon enough a transition plan. So we are in the best position to know what impact we have. So we might as well make a plan to address the impact and be prepared when the regulation comes into effect or a litigation challenge comes, because that's also likely to happen, especially in the absence of comprehensive regulation. So the company will be prepared to address that.
Thank you. And thank you very much, Statis. I think that in terms of the assessment of double materiality and also the transition planning, there's an important topic to raise is the carbon pricing, which is not unified today within the global landscape. And the way to implement the legal principles identified in the advisor opinion is for the states to develop a unified global approach to carbon pricing. The World Bank has reported that in 2025, 80 emission trading and carbon taxes have been implemented, and 28% of global emissions are covered by a direct carbon price only. This is what was mentioned by Anna. At present, national carbon pricing systems such as Euro carbon border adjustment mechanism have different ways of measuring how carbon should be priced, and this leads to problems. Could you please, Anna, explain if up to you if you think that the globally harmonized carbon pricing framework is politically and possible? And Frank, I would like your opinion about the compliance and dispute risks arising from the fact that the companies are actually operating across different carbon pricing regimes.
Thank you, Anna, for your question. Okay, first to answer it, I would say that it is we are in a difficult moment. I mean, from a geopolitical point of view, and at the time of taking decisions. But having said this, I'm going to say why it is a bit difficult, and the international community is working on this. I mean, to try to harmonize or to establish some rules that give some level playing field. Okay. We have to take into consideration that carbon pricing is a tool to facilitate decarbonization. And decarbonization has to be done, as the ICJ has mentioned, through international cooperation. It's one of the obligations to address climate change according to the ICJ. I mean, according to customary international law, even before this advisory opinion. And a uniform carbon price or equivalent policies will assist to decarbonization. And now we have, and what has been very controversial, not only taxation, but also the carbon border adjustment mechanism. But I mean, there are carbon adjustment mechanisms that are being implemented in, I mean, it's going to be implemented in, not worldwide, but in third-time geographies. And it's a good mechanism in a world in which carbon pricing it's incomplete, but it's difficult and complex because it is very important also to recognize other carbon pricing systems paid in the country of origin to be fair and in compliance with the WTO rules, okay? And in fact, to establish harmonized rules and technical assessments, this can be done through coalitions. And I would like to emphasize that during COP30, it was launched by the presidency, I mean, by Brazilian presidency, the Open Coalition on Compliance Carbon Markets, okay? And the aim of this coalition is to create a globally consistent framework for regulated carbon markets, aiming for greater liquidity, transparency, and effectiveness in decarbonization through shared standards for monitoring, reporting, and verification and linking national systems. So now the international community has started to work to try to harmonize or to establish some harmonized rules for carbon markets. But in any case, also there has been some warnings, like, for example, the economist Joseph Stiglitz has warned that unilateral carbon border adjustments that are imposed without dialogue can represent a disadvantage for developing countries, and it won't be in line with the principle of common but differentiated responsibilities, which is also one of the principles that are under the UNFCCC and also has been emphasized by the ICJ. So therefore, I think it is difficult to have this kind of harmonization, but there will be, I think that the trend will be the establishment of coalitions. But this is going to take some time given the context that in which we are moving today, and also the controversy around the carbon border adjustment mechanism of the EU that was very controversial during COP30 meetings. And okay, I cannot stand more, but there are more things to be said on this. Thank you.
Thank you, Frank.
Yeah, well, Anna already, and rightfully so, I think, mentioned the complexity that having different systems introduces, and also, I think, for the time being, uncertainty as to where this is going to move exactly, which obviously creates a compliance risk. It's perhaps not much different from having to manage different tax systems in different jurisdictions. So it can be done, but it requires work and focus for the management to do that and to make sure that they are in control. And I think even if the system will be harmonized, there's still potential litigation risk in that these rules, if you look at the EU, for instance, are being applied by the national regulators in the first instance, and they still may have different interpretations with regard to the same system. We've seen something similar, for instance, with the RED, which is the Renewable Fuels Directive, where regulators have different interpretations as to the rules which creates a litigation risk with the regulator. Obviously, if you rely on a certain interpretation of the rule, the regulator is not going to uphold that. I mean, at the end of the day, at least in Europe, the European Court of Justice will level the playing field, so to speak, but that takes a lot of time usually.
Thank you. It seems to me that there is the very high level of uncertainty, and the risk arising around this lack of unified regulation, lack of unified carbon pricing regimes, and the situations are particularly complex for the boards of directors. And in this respect, how you think, Caroline and Statis, it would have an impact of accountability of the boards and the way they structure and design the strategies with such a huge uncertainty and the lack of the clear measures existing for the carbon emission environment.
Statis, do you want to start? It's fine for me.
Thank you. That's fine. I guess there would be 5 headings in how you board should approach it. First of all, I think you have to improve the board confidence and its readiness to address those issues, and that in some cases may take quite a lot of doing. There have to be organizational measures that have to be taken. I mentioned the transition planning preparation, so that's one of them. Obviously, there have to be compliance and litigation risk management. That in itself has already been touched upon, and I think it's obviously extremely important. There's got to be stakeholder engagement and communication. That's one way of actually protecting the company, but also raising awareness of the ways in which it deals with the problem. And finally, there's got to be cost and efficiency monitoring, so that, among other things, what we say is what we do. Now, each of those headings has some detail, but maybe I'll let Caroline go, and then I can return if time permits.
Thank you, Statis. Yes, I fully agree with what you just said. I would maybe add one thing that is very much important in terms of understanding the functioning of bodies to the company. There's one specificity of the board of directors that is differentiating the board of director from the management. Is the board of director is a long-term body. So in that respect, is the one that is expected to have a long-term vision of the topic. So having said, I'm not going to repeat the tools or the approaches that Statis has just suggested. My point will be to answer the question how board members will make sure that they will track this question on the long run. Because it's one thing to implement a transitional plan, it's one thing to use the double materiality tool approach and so on. The question is on the long run, how the board is going to make sure that the plan is implemented. Because one of the core questions in companies is on the one hand you're setting up the strategy, but the second point, which is in most cases the vulnerability point, is how you make sure that the strategy in that respect, the climate strategy, is fully and well implemented. So that's one thing I would like to insist on, because I think for me it's very, very important. And the second tool that has not been mentioned, and that's for me very much important, is a risk cartography tool. It's a very efficient way to make sure that, boards are engaging on the long run with the topic, and because they are supposed to at least every year to set up the risk cartography, sometimes to renew it. And risk cartography means also that you need to work on the frequency and the probability of the risk emerging. So that's a very efficient tool board members have to use and to be very strict on, because and last but not least, as I mentioned before, one of the core challenge for board members is that they have to articulate numerous constraints and risk, and the cartography risk is a very efficient tool to articulate those different tools and to mitigate them, because the question is not how you're going to deal with this risk. The question is how you be able as a board member, and when you set up a strategy, when you review the strategy, how you're going to articulate these different risks that may at some point be conflicted. So I would just insist of these two things. The board is a long-term body that is, in that respect, very much in charge of tracking this issue. Second, the board members have to be sure that the strategy, the transitional plan and the strategy in climate change is fully implemented. And last but not least, they need to articulate alongside their, the strategy implementation, the numerous risks that have been, I'll say, pointed out by board members when they set up the risk cartography. Thank you.
Yeah, I think I fully agree with Caroline. And as an example of specific things that might be emphasized more after the ICJ and what it has said is the need to integrate climate strategy more fully. And this cartography of risk is, I think, very much on point. I think that's an excellent point. Considering whether you can produce additional incentives and remuneration for compliance with climate goals, because that is a generally accepted effective tool to drive the way in which a company operates. I think emphasize sustainability oversight. I think one of the risks that may have increased after the ICJ is greenwashing. Because if companies feel the pressure to show that they're climate compliant, they may say things that are not fully accurate, and that may be an exposure that doesn't have to do on the way in which they impact, but on the way in which they present themselves. So I think it's very important to make sure we don't have a sort of greenwashing. And I think clearly there needs to be more emphasis on awareness of developing regulation and litigation. ICJ is an advisory opinion, but there have been decisions at the European Court of Human Rights. There have been some decisions in national courts, and I expect there will be more. So that needs to be watched with extreme care.
Thank you. Thank you very much, both of you. The International Court of Justice emphasized that the fossil fuel production, fossil fuel consumption, and the granting of fossil fuel exploration licenses or the provision of fossil fuel subsidies might constitute an internationally wrongful act, which is attributable to the state which is issuing these licenses. It has implications for international treaties that protect foreign investment, including inflows in fossil fuels, because the investment treaties may have the chilling effect on climate action, with the state delaying and diluting the measures against the carbon emissions. So one of the possible solutions would be to reform the international investment treaty environment and practice. The other one would be to have the bilateral investment treaties between the countries to ensure the investor obligations are strong enough to protect the environment and social responsibility. I'll turn to Frank with the question, what do you think? Because today, with the recent decision of Donald Trump to withdraw from the climate treaties, it will be still possible to enforce the United Nations Framework Convention against climate change, on which the Paris Agreement is based, against the US companies?
probably not in the United States, but I mean, a lot of American companies have subsidiaries around the globe, including in the European Union. And from that perspective, there may be possibilities to enforce these obligations against those companies before the European courts. The question, of course, becomes, you know, is it sufficient to engage a European intermediate holding company to enforce these obligations, or do you need to file against the top company? But even then, on the basis of, I won't bore you with European jurisdictional laws, but there are possibilities to join the US parent in an action before the European courts. The question then is, can you enforce it in the United States? Will the courts in the United States recognize that judgment and accept enforcement of it? I think that is an open question. To date, it depends a bit from state to state, but courts in the United States recognize and enforce judgments from European countries on the basis of comity and reciprocity. Chances are, of course, that if that is done by a state court or a federal court in the United States, that the Trump administration will introduce legislation to prevent that. But it's all an open question. But to your question, yes, there are possibilities, but they are somewhat rife with complications. But that is life in international litigation anyway. So.
Thank you. So what do you think, Anna, the renegotiation of investment treaties, or the putting the system of new framework on investment treaties, do you think it is something that is reasonable, it is possible to have it in terms of the international convention and environment?
Yes, thank you, Anna. Yes, first of all, before reforming, I would think that it's very also important how you interpret these treaties. And in fact, in the separate opinion, and I'm saying because reform takes a lot of negotiation efforts and takes years. Okay, I'm not saying that it shouldn't be reformed. In fact, as there are around 2,500 investment treaties, it has been proposed already that there should be just one multilateral treaty that reforms all. But again, I mean, at this moment, I would say it's not good times for international public law. I mean, for negotiations, it's very difficult. But the Judge Cleveland of the ICJ, in its separate opinion, it emphasizes that the interpretation of investment instruments must be informed by states' obligations in respect of climate change under international law. So when you interpret one of these treaties, it has to be considered all the, I mean, what the advisory opinion says, together with, of course, many instruments, and not only the main three conventions, but also the UNCLOS, the United Nations Convention on the Law of the Sea, the Biodiversity Convention, or human rights, the Certification Convention, and many other legislations, okay? And also, it's very important that we have to take into consideration that, for example, I mean, coal, oil, and gas account for more than 75% of emissions and nearly 90% of carbon dioxide. And 3/4 of foreign-owned coal power plants worldwide are protected by at least one investment treaty. And also coal, oil, and gas projects are also subject to investment treaty coverage, okay? So regarding the treaty interpretation, as it has been said by Judge Cleveland, climate obligations can inform these treaties, okay? And it will start with, for example, with the interpretation of investment protection standards. For example, the circumstances under which a measure should be deemed an expropriation, requiring the state to compensate investors, and the normative content of the fair and equitable treatment standard on which most investors' state dispute settlement claims are brought and won. So there are many aspects to be reconsidered when these treaties are interpreted. Of course, reform will be the best option, but at this time, it is very, very difficult.
Yeah. Yes, thank you. So currently we have this environment of bilateral investment treaties, which frequently support the fossil fuel industries, and which are actually contrary to what was advised in the opinion by International Court of Justice, and which creates strong risk on the companies investing in the countries and in different businesses, by the way, because they could also consume fossil fuels directly, and this way be in breach of the Paris Agreement. What do you think about the investor obligations in this respect, and how the boards could monitor the investment decisions based on this very complex environment between the investment treaties that are supposed to protect the investment, but in certain way they do not? So please, Caroline and Statis, what is your opinion about the investor obligations regarding environmental protection and the social responsibility, and how the boards should, on which kind of practices they should rely to limit the risks of liability?
Statis, please feel free to start.
Okay, thank you. Obviously, they need to be to understand the risks and the solutions. I think they are likely to need expert advice because it's in some ways a highly technical issue, and they need to be able to challenge investees on how they deal with the risk. I mean, so it's actually quite a high standard to which they have to comply. Clearly, they need to be very familiar with regulatory trends as well as with litigation trends. As Caroline pointed out, risk cartography is another very significant tool. They have to develop their own risk cartography, which will include climate risk. They need to consider trade-offs between financial gains and climate costs. And I think they also need to monitor consistency between what investees say about their performance and what they actually do. So I think the burden on investors is not insignificant.
Yeah. Well, first comment to your question, Anna. I think that regarding this risk, I would first say that there is no specific answer for this specific risk. And let me elaborate a little. Can you hear me? Yeah. The first thing I would like to remind or to say again is one of the most challenging now tasks for board members is how they're going to articulate those different risks. And as Statis just mentioned it before, the climate risk is very much, I would say, in line or has to be articulated with this high pressure coming from the geopolitical risks. So in other words, what you are addressing is how board members are expected to address different topics and risks, and how they will articulate them, and how they will build up the strategy of the company in that respect, and mostly with a strong focus on the climate change, as we mentioned before. I think the answer for me is double. on the one hand, of course, it's a question of competencies, and you have to make sure that some board members got a deep knowledge and understanding of the climate change topic and challenges, and they are able to articulate those risks with these others. And so the question is, when you are not a specialist of this question as a board member, how do you engage into this topic? And the question, and which raised the second answer, which is the processes. Okay, in the most common answer is to concentrate the topic into a specific committee. What would be the environmental committee or SR committee that will host competences in order to prepare board sessions on the environmental topics and help the board to make the right decision, or at least to have a better understanding of the challenges, the regulatory risk, and so on. But the thing is, when having say so, you are entering with, I think, a huge problem in companies, which I call the asymmetry, information asymmetry. The question is, in any company, board members tend to consider that they are provided with a non-biased and complete information, and regarding in the respect of the climate change information. As a matter of fact, and since the management is a permanent body compared to the board that is an intermittent body, board members got biased and incomplete information. And in that respect, since the climate change regulation and topic in itself is extremely complex, for me, one of the core challenge for board members is to make sure that they have been provided with the full information first, and that the information is clear enough so they are able to make the right decision. So the question for me mostly, and which is not specifically something that is only a topic for the climate change topic, but I would say it's also a question for any kind of topic that board members have to deal with. The question is how, as a board member, how do you eliminate the information asymmetry to ensure that you will receive the most complete and objective information in this field? So one remedy will be for board members to engage very frequently on the long run, once again, from time to time, with executives that are in charge with the topics, and at least once a year. So they make sure that if they have a good understanding first of what's going on, they have a direct access to the information, and last but not least, they are able to readjust, reboot the strategy when they think that the trajectory is not good enough. I would just like to add something in that respect regarding the overall environment that is very challenging now, very much complex. With I would say time is getting more and more fast. A strategy, a 5-year strategy is kind of an essence. You know, you need to reboot the strategy more frequently. So I think that having this access to the information is very crucial. This is a prerequisite. You can set up all the processes. You can have the more talented people on the board. If they don't have the right information on time, they won't be able to set up the right strategy. They won't be able to control whether the strategy is well implemented or not. So I will really once again focus on this issue of information asymmetry. That is for me one of the core answer to the good response to those topics from board members.
Thank you. So I think that it requires a major shift in terms of competencies and access to information from different sources, and a deep dive of the board members into the executives. It's really very demanding. Thank you very much. The last question is about the omnibus and the regulatory changes in Europe. How do you think it will? How the International Court of Justice ruling influenced this regulatory changes, and do you think that they may conflict the omnibus and what was ruled by the European authorities. It is conflicting the urgent action obligations that the International Court of Justice identified. So Anna and Frank, could the EU regulatory regression, because I would call it regression, open grounds for litigation or international challenge?
Yeah, following the same order as the previous questions. Okay, I see here there is, as you mentioned, there is a regression, and there is a principle under international law, although it is, I mean, it's not really written in this manner in the Paris Agreement, which is the principle of non-regression, which is, for example, for NDCs, always said that it has to be a progressive NDC every 5 years. So then under this principle, the principle of non-regression, and in fact, during the negotiations impelled by Macron, 7 years ago, before the United Nations General Assembly for a Global Pact for the Environment, this principle was there, but finally this Global Pact for the Environment, it was not included. But under the EU law, there is this principle recognized in the treaties, not written as such. So then I think that, of course, there are risks of litigation, but I would say against even the European institutions more than boards, because there are even companies during the regression of the corporate sustainability reporting regulation and the due diligence directive, that they have complained. Even we were talking about transition plans, and now it's not a compulsory to develop a transition plan. So there are companies that to have a certain playing level field, they might be willing to file a case against this regression. And of course, we have NGOs that they are already talking about this. And according to what it has been said in the advisory opinion, for example, there is an obligation not to cause environmental damage or environmental harm. And also there is not only regression regarding obligations of reporting and due diligence, but also there are new omnibus on the table to reduce obligations on environmental impact assessments. And environmental impact assessments are a tool that people has been complaining about companies because it takes time. That is true. But at the same time, it's a guardrail to protect the environment. So diminishing the protection through all these kind of mechanisms that has been developed in the last 50 years in international environmental law and after national environmental law, it presents risks of litigation, definitely. I see that there might be cases ongoing, but again, I repeat, more against institutions, I mean, public institutions that are diminishing and making all these legislative changes and amendments to what we had established to protect the environment previously.
Thank you very much, Anna. Frank, you think that the risk is mainly on the institutions, and we will wait and see how it evolves to know what kinds of the litigation or the risk could be imposed on the companies based on the way they actually operate under omnibus compared to they were supposed to operate under the older system, which was much more in matching with the international obligations.
Well, I think this is all horizon scanning, of course. So with that proviso, I would say that as a general proposition, states or European institutions regressing And in that sense, leaving a vacuum presents a litigation risk to companies as well, because NGOs will want to find a way to, from a strategic perspective, get what they want, and that is ambitious reduction paths. So I think with these regressions, the risk is twofold. One is, I think, litigation against corporates on their reduction plans, and whether they are ambitious enough or not, whether they are effective, whether it makes sense to make certain investments, for instance, in fuel-related assets, or continue to produce and develop fossil fueled cars, but to name a few. And I think the other is around transparency and strategy setting, especially against boards. We already have seen that happening in the UK, where Client Earth filed a case against the board of Shell, which was unsuccessful in that case. But I think the pressure will continue to be on, and creative strategies may be developed by NGOs and the like to litigate against companies. And even if it's unsuccessful, it may serve a strategic purpose. And obviously, it consumes board time, and especially if it's directly against board members, it's also a strain from an emotional perspective, I would say.
Thank you. Thank you. And Caroline Statis, how do you think that the board should react to this regulatory regression in light of international reporting schemes? Because in Europe we have this regression, and we have at the same time the Chinese sustainability regulation, and also ISSB, which is adopted as a voluntary scheme, or more or less voluntary scheme, in around 70 countries, I believe. In terms of the investor right protections, how do you think that the boards would be how they should react to this? What they should adopt to protect themselves against the breach, for example, of a fiduciary duty?
Statis, do you want to start?
Yes, that's fine. Thank you, Caroline. I mean, I fully agree with what Frank said, because my view is that when you comply with regulation, you can make a prima facie case that you have addressed the corresponding risk. However, when regulation can be shown to be out of line with the actual risks, then I think your litigation exposure increases. So I think management here needs to address more than simply compliance. It has to look directly to the risk, to the harm that's potentially caused, and see how that can be addressed. So due diligence becomes even more important, and it goes far beyond compliance. And so it may take some additional measures. For instance, you can adopt the ISSB standards to demonstrate that you look beyond the shifting and uncertain regulatory environment, and you actually are concerned about the actual harm that may be caused. Thank you.
I think from a point of view, I think this is the most complex question any company is now facing. We need to remind that most companies are operating in an open world, and they are facing numerous regulations and environments. So the mistake for me from the board perspective would be to treat this issue, the one you are mentioning, and how to cope with the regulation and the investors' right protection. The mistake will be to treat this issue separately. Once again, I'm sorry to mention it, and don't get me wrong, I really think that the climate change is a highly important topic. Once again, as a board member, you need to mitigate this question, this risk with the other risks. And at the end of the day, the question for you is, how do you finally articulate the different risks, and what is your balance? Just let me give you a very simple example. You have on the one hand this climate regulation. On the other hand, you have the lawfare issue, which is now putting a lot of pressures on companies. So having said so, for me, the way is a question of finding the right balance between these different regulation, different pressures, and having. And I would end these remarks with one core reminder: is that for any company, their best assets are investors. So how can you combine, this expectation of meeting investors' expectations and demands on the one hand, and all the risks you need to articulate, and at the end of the day, because as a company, you are supposed to create financial value. Otherwise, this is your first your first responsibility, and you need to have this in mind all the time. So I'm sorry, my answer is not very satisfactory. I have a sense, but nevertheless, I think since the environment is getting so complex with so much pressure on companies, which are most of them trying to survive and make sure that still able to create financial value to survive. The question is how they're going to balance all these different topics, all these different risks. And once again, I think it's a case-by-case answer with, in all situations, this obvious and main, objective, that is to make sure that you are meeting most of your investors' demands and expectations, because a company with a very unfully investors are very, very vulnerable today.
Thank you very much. So it is very clear that you suggest, and it is extremely important for the board to when defining the transparency and disclosure standards to listen to investors, and all of this despite the regulatory regression that we see on European level. Thank you very much. Now, Anna, you would like to add something very quickly?
Yes, very quickly. Yes. I would like to say that regarding regression, it's not the regression itself that is creating the risk of litigation against companies. That the risk has been there already, even before regression. So it's because there is that risk, and it's not because the European Union is doing that. Even not only the European Union, is happening in the US as well. So even if a company decides to do a transition plan, even if it's not compulsory, it has to be in line with the advisory opinion and with what the Paris Agreement says. So it doesn't matter the regression. So that was the core of my answer before. Yeah. Okay. Thank you for giving me the floor. Thank you.
Thank you very much. We are now moving to the pool.
Anna,
yes?
Can I add something? I just want to say I fully agree, which is because the question of regression is very complex, and I fully agree. That's all. Thank you.
So we have two questions for you. Thank you very much to answer them. It's relevant to the question 4 and question 5 in particular.
I'm sorry, for me, you mean, Anna?
No. It is you are passing to the pool. Do you have the pool? Do you see the pool on the screen?
So I can just intervene. Anybody can answer, and of course it would be good. Anna would ask you as panel to actually comment on the results coming up shortly when we had a bit of more people answering. So the first question is whether you actually are looking more to the Paris-aligned investments versus the bilateral investment treaties when you're taking decisions in your board. And the other one is around if the investor dialogue is the prime guide for you when you consider transparency and your reporting.
Can I answer regarding the dialogue?
We will see the answers of the participants.
Okay, sorry.
And then they will comment, and everything is anonymous.
So it's all anonymous, and I'll be closing the poll in 3 seconds. So do answer quickly. Okay, I will close the poll now. And here's the result. Back to you, Anna.
Yes, so we have quite positive results. We have 45%, so it will be less than the half for the first question regarding the reliance on the Paris-aligned investments and Paris Agreement aligned investments compared to the bilateral investment treaties, which means that we have much more reliance, and the protection it is sought under the bilateral agreements, which are not always and very rarely actually.
Anna, maybe you want the panel to comment and actually maybe more out of a board perspective, if you can.
Yes.
So what do you see boards actually doing? Because in fact, we see 35% not going for the Paris alignment here. So where do you find the board's discussion on this? And maybe you can ask Statis, what's your comment?
I'm not sure that boards in Greece are sufficiently focused on the provisions of international treaties. So I would tend in this case to consider the answer to be neutral. Some may not. Disagreeing would be for me a step too far. And I'm also I think it's more the investor dialogue that would drive board decisions in this case. But that is a point in time that may very well change quickly.
Right. And Caroline, especially on the investor dialogue side, is that on your boards primarily directed towards the investor as assessment on what you're going to report, or how is that discussion going?
Can you hear me? I'm not sure. Can you hear me?
Yeah.
Okay, sorry. I kind of agree with Statis, and I think that's very true. There's still progress to be done, I think. Talking about board and board members being very much committed on this question. The fact is, it is very complex. This is, I think, one of the reasons. And one way to maybe to force board members to enter fully into the topic is really to put on the agenda the engagement with investors, because they have once again they have high expectations, and not to mention that a lot of investors have a good understanding of these questions, and sometimes much better than the board members themselves, which is a question. Once again, I'm very much neutral about that, because you cannot ask board members to be fully aware of any topic, and there are so many topics now in the boardroom. So the question is mostly how, once again, as I mentioned before, how do board members get the information in order to be able to engage very properly with investors? This is one answer. The second answer is to be very much transparent as much as you can, which we know it's very complex when the company is listed, because you need to deal with the confidentiality of information. But anyhow, you need to show the environment, stakeholders, shareholders, they are very much eager to enter into a dialogue, and you're not hiding behind the veil of the boardroom, not to talk. But this is also not that simple, because having said so, you need to organize this engagement. It's not just saying I'm going to engage. Of course, there are some people which job is to engage with investors into the company, but now more and more investors are eager to engage with board members, with executives. And this is, on the one hand, a good thing. On the other hand, you need to be very careful the way you engage. And this is you need to set up a canvas, a framework. You need to establish a process. You cannot just say, okay, I'm more or less the right person on the board to deal with this question. I'm more aware of the issue that the others I'm going to engage. It's much more complex. So once, and mostly when the company is listed with subsidiaries and so on, and because also you need to cope with different regulations. So for me, just to summarize, is of course engagement. Second, to secure the engagement process and to frame it so it's a very disciplined process. And third, we never. One very important thing: nobody mentioned the importance of the chairman of the board. The chairman of the board has a core role in that question. If you have a chairman, a chairwoman, very much reluctant to treat this question, obviously the board won't have a very core commitment into this question. If, on the other hand, you have a chairman or chairwoman very much convinced about the importance of the topic, of course, it will be much easier for the board to embark the question, the regulation, to be much more aware of what's going on. So once again, and sorry to insist, there is no specific treatment on the climate change question. All the questions are really triggering the overall question is how board members, and among them the chairman, the chairwoman, are embarking all the risk, and how they are articulating all the risk, and how they make sure that at the end of the day, the strategy is a balanced one and is able to be well shared with their investors. Because at the end of the day, what you really need as a board member, as an executive, to make sure that the investors understand your strategy and they will follow you, although you are getting through difficult periods. Thank you.
Thank you very much. So it means that the investor rights protection is the major the major topic actually to be covered by the board, and they have to ensure it. And what is not easy at all in the environment where we have different standards of investor protection rights in Europe. A different investor, in different courts. So I think it's extremely complex question. It's a dialogue. It has a special place. Yeah.
And maybe I will, sorry to mention that, I will just add one other question. The question of communication. As you know, that the board is responsible for the communication of the company, financial and non-financial communication. This is also a very important tool for the board to be very much engaged into this topic. And one, I think companies need to be very careful about communication, because you need to say what you do, but you need to do what you say. And investors are very, very sensitive to those questions now. And one of the tool to challenge and even to trigger a board member's liabilities is communication. So that's something also I would like to put into the discussion, because board members tend to forget about the importance of communication as a tool, of course, as a way to share the strategy, as a way to engage with their stakeholders, but also as a way to be triggered as board member in the liability. So that's something also I wanted to add.
Thank you very much. I think we run out of time. I would like to add that we have some new events coming soon that within our network. We have in Chapter 0 Netherlands, will be the navigating sustainability, where board responsibility meets legal liability. There is an event organized on the February 13. There is also a training on responsible artificial intelligence for value creation that is starting very soon, and it is still possible to enroll before January 19th. It is organized by Board Impact Forum, and it is very interesting because this is online and also in person in Stockholm. And the last event we organized at Chapter Zero France, a climate lab on January 20 at Deloitte, when you will be able to ask different questions on the scientific justification and scientific demonstration of the impact on the climate change on the physical standing of the company and its assets. So hopefully we will be able to join. I would like to thank all the presenters and all the participants. I would like to thank you, Anna, Caroline, Frank, and Statis for your input. It is very valuable. And also, we would like to thank all the contributing chapters for the joint work on this webinar. And we don't forget our partners and sponsors from Chapter Zero France, who support us with this mission. And we are really delighted to having you all on board, and hope that it will be helpful for your board works in the future. Thank you very much.